Just to finish Senator Blumenthal's point, I hope you realize how ridiculous the four of you look. Spouting these preposterous, canned answers in a forum in which A, you're supposed to tell the truth, and B, you're supposed to demonstrate the judicial capacity to make independent, factual decisions in hard cases. If you can't even sit here and say that Joe Biden won that election or that the Capitol was attacked, what's left? What's left if a hard case comes your way as a judge, and let's say the Trump administration is bearing down on that? Why would we ever believe that you would give the litigants a fair hearing and a fair decision if the executive branch was leaning in on you when we can't get a reasonable answer out of any of you with the executive branch leaning in on you to give these ridiculous answers today? I'm really sorry to have to go through this and that you have to go through this. But it would be nice if you could tell your executive branch handlers, for instance, Ms.
Would rather watch paint dry than sit through a Senate judicial confirmation hearing. It's usually a festival of legalese, vague promises about precedent, and enough procedural jargon to bore a robot to tears. But lately, something has shifted. These once stuffy affairs have transformed into high-stakes political theater, and not the fun kind with singing and dancing. The focus has moved away from a candidate's legal mind and toward their political allegiance. It's less about whether they can interpret the law and more about whether they will be a reliable vote for a particular party's agenda. And that, my friends, is a terrifying development for anyone who might, one day need a court to be fair. The problem is that public trust in our institutions is already circling the drain. You just have to look at the news from the past year. We saw the Department of Justice launch a frankly insane criminal probe into the Federal Reserve Chair, Jerome Powell, in January, seemingly because the president was mad about interest rates. That's like getting the FBI to investigate your toaster for burning your bagel. It's an abuse of power that makes independent institutions feel a lot less independent. When that same atmosphere of political pressure bleeds into the process of selecting lifetime appointed judges, the very foundation of impartial justice starts to crack. People begin to see the black robes as just another team jersey. This shift isn't just some inside baseball political drama, it fundamentally changes the deal we have with our justice system. We are supposed to believe that when we enter a courtroom, the person on the bench is a neutral arbiter, an umpire calling balls and strikes based on a settled rule book. But when the selection process itself becomes a partisan blood sport, that belief becomes incredibly hard to maintain. The hearings become less about vetting a qualified jurist and more about scoring political points for the cameras. The questions are designed not to elicit information about legal philosophy, but to create sound bites and trip up the nominee into making a politically damaging statement. And that is precisely why we should all be paying attention.
Ask a different question, a legal question. A judge, you want to be judges. A judge gets a threat to the judge's life or to the judge's family. Can you imagine a scenario in which liability may attach to individuals beyond the utterer of that threat? Ms. Clark?
Senator, as a prosecutor, there are instances where there's some responsibility that is assigned to someone who is not the utterer of a threat to an individual. And so to answer your question, yes, I can imagine.
Do you agree?
Yes, Senator, and if confirmed to the bench, I would follow all Supreme Court precedent and Ninth Circuit precedent.
Mr. Rick, you agree?
Yes, Senator, I would agree with that.
I don't know that I care what you think, Ms. Westerkamp, because you're going to international trade and you're probably not going to see much of this, but do you agree?
Yes, Senator.
Yeah, and those doctrines that would provide the legal basis for investigation in those scenarios would include doctrines like, name one, Ms. Clark.
Senator, doctrines that are, if someone is essentially carrying out
Solicitation, would that be
Yes.
one?
Yeah.
Solicitation of a
Yes.
threat?
Yes.
Or a conspiracy out of which the threat emerged, would that be another one?
Yes.
Yes. How about, and it's the product of an enterprise under the racketeering statutes. Would that also be another way that liability could extend beyond the utterer?
That is correct, Senator.
Can you think of any others, Ms. Lane, where liability extends beyond the utterer of the threat? What are some of the legal theories that would support that kind of investigation and prosecution?
Senator, the doctrines you mentioned, I would agree with, and I would just look always to the federal law and federal statutes guiding that.
Mr. Recchi?
Senator, I would agree with that. I think you covered the major ones, conspiracy, RICO. There may be other avenues of potential legal liability, but I think you covered the three big ones in that scenario.
Ms. Westerkamp, you agree?
Senator, I'm not aware if there are any more with my practice before the Court of International Trade and Court of Federal Claims that doesn't touch on criminal law.
So here's why I asked you these questions. I asked you these questions because right now federal judges are under the worst shadow of physical threat in my lifetime and perhaps in the history of this country. And in responding to those threats, we have the United States Marshal Service, which reports to the Department of Justice. And I have now over a dozen times asked the Marshal Service, will you investigate behind the utterer of a threat if the evidence justifies it? That's a super easy question. The answer is, yeah, of course we will. They won't answer that. They won't answer that. And I point this out because judges across the country need to pay attention to the fact that the Marshal Service won't confirm that it will investigate behind the utterer of a threat if the evidence supports that. And why would that be the case? That would be the case because when you get behind the utterer of a lot of these threats, you run into right-wing conspiracies. And this MAGA Department of Justice would rather not go there. And so they leave judges exposed with investigations in which they aren't doing investigative 101 work that you've all identified as plausible legal theories. And we need to fix that. We need to fix that.
This isn't just about the fate of one nominee or the power balance in the Senate. It's about the long-term health of our democracy, when the courts are no longer seen as a place for law, but as another arena for political warfare. We lose the one branch of government designed to be above the fray. The slow, deliberate erosion of that trust is happening right now, in brightly lit hearing rooms, one politically charged question at a time. It's a slow-motion car crash, and we are all in the back seat, whether we are watching or not. Or, to really understand what's going on, you have to see the two different types of questions a nominee faces. It's a tale of two interrogations. First, you have the classic legal questions. These are the bread and butter of judicial philosophy. A senator might ask, "Judge, could you explain your understanding of the Chevron deference?" Or, "What is your approach to statutory interpretation?" These questions, while a bit dry, are crucial. They are designed to probe the nominee's intellect, their respect for legal history, and their methodological approach to deciding cases. Answering them requires a deep knowledge of the law and a commitment to established principles. It's the boring, but necessary part of the job interview. Then, there's the other kind of question, the political loyalty test. This is where things get ugly. Instead of asking about legal doctrine, a senator might ask, "Do you agree that the recent FCC investigations into news outlets, as defended by Chairman Carr, are a necessary check on media bias? Or given the unprecedented government shutdown last year, would you support the president's view on executive authority during a national crisis?" These questions aren't about the law. They are traps. They are designed to force the nominee to pick a side in a current political fight, effectively demanding they pledge allegiance not to the Constitution, but to a party's talking points. The difference is stark. A legal question asks, "How do you think?" A political question asks, "Who are you with?" One seeks to understand a nominee's judicial temperament, while the other seeks to confirm their political reliability. Think about it. A judge's job is to apply the law to the facts, regardless of who the parties are. Whether the person before the court is a popular politician or an unknown citizen, the law should be the same.